Ms. Farr, are you needing more time to go for your report?
Yes, Your Honor. I haven't been able to reach Mom. I don't have a good number for her. The number I have is not working.
How far out would you like to put this?
If I can talk with her this week, we can put it out for maybe 2 weeks.
Okay.
And Your Honor, I've been appointed to represent the mother.
Have you had contact with her?
Yes.
Oh,
She came to my office. I asked her to come to my office and she did. And I interviewed her.
okay.
And she was here. Oh yeah, she's here. Kendra Rapp is here.
So, yeah, she was, I saw her.
She's here. Yeah, she's here.
So, Mr. Anagnostou, could you provide me a good number through email for Mom?
Sure.
Thank you.
All right, let's do that. Then we can put it out to June 6th. And hopefully have the report in at that time. I'll extend the immediate emergency minor guardianship until June 6th. And
Thank you.
is Chris Waldo here? There we are. All right, two things that I've been working on since last time we got together. And that is, and maybe Ms. Winkles can weigh in. Damian Waldo is a minor. He's, what is he now, 16 or 17?
17.
17. He's requested an attorney, and I would like to appoint you for him.
I will be happy to accept it, and I can already tell I don't have a conflict with this.
Okay. And then for Chris Waldo, I'm going to appoint an attorney named Donald Esau, and I was just able to get Mr. Esau to agree to do that this week. So I need to do both of those appointments and then put this over to have both counsel meet with their clients.
And then who is Ms. Farr the GL on this?
Yes.
Okay, and can you send me the contact information for the child?
Yes.
Okay. Mr. Sasuda, any questions about that? We'll pick a time.
No, my only question was that he hadn't heard anything since the previous airing, and I just wanted to make sure it didn't fall through the cracks.
Yeah. I needed to do some work to make sure that this got lined up. So now we're moving forward. And have you had a chance to talk to the girlfriend, Ms. Farr?
Yes, I did.
Okay.
Sorry, I was trying to connect the dots there. Yes, I did talk with her, and I am ready to write my report. I just haven't had the time to do that, so I'll try to get that done this week.
Okay. Well, I need to give counsel time to meet with her clients. I think we need to go about 3 weeks out on this case at least. So that would be to June 13th.
And just so the court is aware, I have a trial every single week in June, but I will try to pop out of the trial. It should be on a Tuesday and come into home.
Okay. If I need to call you at the beginning or end of the docket, just let me know. We'll work with
Absolutely.
that. All right. Mr. Waldo, attorney named Donald Esau should be reaching out to you in order to discuss this case with you and represent your interests.
Okay, thank you.
Okay. Thank you, sir. All right. That's it on Waldo. We'll see everybody back on June 13th.
No, Your Honor, and
All right,
we've
thank you.
received no response. I'm not sure. I believe she had counsel appointed.
I appointed Mr. Goodday for her, but I can't guarantee that Mr. Goodday is aware of that at this point. So I need to make sure that
Long run the
happens.
full. But in any event, we definitely need the 60-day because the child has medical issues.
All right. So the current emergency order expires on June 10th. I will extend it 60 days beyond June 10th. We probably can put this out a month or 6 weeks at this point with that extension.
I would ask for 6 weeks, just given my massive trial schedule in the month of June.
Okay. Let's go for July 11th then.
Perfect. Thank you.
And I haven't calculated the, be around August 9th is when the second 60 days will expire.
And I'll calculate that, Your Honor, and I'll get you an order.
Okay, I appreciate that. So we'll put this over to
Yes, sir.
July. Anyone else appearing on that case? All right. It appears that there's been a consent filed. There was service on the mother. And let me just check one thing. We're here on a full guardianship petition. I need to ask, what is tell me about the father. He wasn't listed on the petition. I don't know if he's on the birth certificate.
There's no father listed on the birth certificate, and there's been no paternity found. She's had 2 gentlemen already tested for paternity but came back negative.
Okay. Well, that was my next question, was there a paternity proceeding? So, well, it appears to me that everything is appropriate to go ahead and enter the order at this time for the full guardianship. For what it's worth, I'll let you know that your pleadings in this case were a model of how it should be done. So I appreciate your good work on that.
I did a lot of that paperwork on my own. Thank you very much.
You bet. Do we have an order on that? Noah Smith? Okay. So the last thing then I need you to do is fill out a minor guardianship order and submit it to the clerk's office for me to sign. Okay.
And I also have a paperwork that says acceptance of appointment of guardian conservator.
You should
Do I need to turn that in?
Yeah, you should sign that and turn that in also.
Okay, perfect.
And then the clerk's office are going to issue what's called letters of guardianship. And that comes from them. Ms. Winkle is here.
Yeah, yes, Your Honor. I don't know if Sandra remembers me. If she wants to call my office again, I can. We had a little legal aid thing. If she wants to call my office, I can tell her what she needs to submit.
Okay, perfect.
So feel free to call Ms. Winkles and she'll help you through the process. Okay.
Thank you so much. You
Ms.
have a great
Winkles
day.
is here.
Okay, you too.
Ms. Hogan-Nickel is here. Ms. Kulawan is here. Ms. Langford is here.
And my client, Your Honor, Ms. Fisher, it's also.
Okay, Ms. Fisher, good. So I've read the declaration by Ms. Fisher, and procedurally where we're at is the emergency minor guardianship ends on June 3rd, and I think that's after the extension. I know there's a full guardianship filed. I wasn't sure if that was scheduled for a trial, though.
It's not, Your Honor. My client will be filing, just so the court's aware, will be filing an objection to that and requesting a different guardian, but we haven't gotten there yet. But I have been in contact with my client several times now, and that should be done before the end of the week.
Okay.
And then I believe Miss Langford has additional information. I believe our declaration stands for itself, so I won't argue that today. But Miss Langford can kind of talk about where she's at in the process.
All right, let's hear from Ms. Langford.
I talked to Melba this weekend. I was actually supposed to go visit yesterday, but I was really sick all weekend, so I didn't want to pass that along. But we did talk for a little bit, just basically what the declaration stated, Angel's wanting to stay at her residence, and she was willing to do so.
Do we need the other proposed guardian, I think it's Melba Harris, was that the name, to file her own minor guardianship petition at this point?
I don't believe so, Your Honor, because the objection allows my client to name a different party. Just so the court's aware, Melba is actually a minor guardian in a different matter. So she has guardianship already. She has gone through that process, but my client will file that. We will need to file a watch report on Melba, but my client can do that as the petitioner, essentially a counterclaim, really, in the objection. The forms actually allow that, and I don't think they did before, so it's a little new to me.
Okay. Ms. Kulawan, any response to all of this?
Yes, we wrote a 5 or 6 page declaration in response to Angel's declaration. It was filed with the court.
I did read that.
Okay.
I did read that.
So
Okay.
that's my position.
All right. Ms. Hogan-Nickel, any response?
I also helped write that, so that's our position.
Okay.
Whatever you decide will be fine. I mean, ultimately, all we wanted is for Angel to be in a stable place and, get the care that she needs. So like she's doing.
I'm actually about to lose jurisdiction, I think, here, because I come in and I set up the emergency minor guardianship, and we are at the end of the 120 days, as I understand it, because we had appointed.
We're actually past the 120 days. The 120 days was over in April.
Well, I think I extended it in April.
Oh, for another 60
No,
days?
another 60 days.
Okay, I missed that. I'm sorry.
Yeah, on April 4th, I extended it. So that would bring it up to about June 3rd. And I can't extend the emergency anymore. If the parties felt necessary to have a guardianship before this got to trial, you know, I guess there's a provision where I could extend the guardianship until the trial date. But I have some thoughts, I guess I wanted to share after reading everything, just maybe to plant some seeds on how to go forward. First of all, it seemed to me when I read the text, and the text went right up to March of this year, that they showed a good relationship with Nancy and Rose, if I can call you that, and not one that is really reflected in the declaration by Ms. Fisher. I guess the question is, Ms. Fisher is now 17. She would like Melba Harris to be the guardian. I think some deference needs to be paid to that. And I guess I'm wondering if maybe, you know, this would be a little bit out of the box, but if the three of you could be guardians and reach an agreement on that, which would give you all three the authority and let Ms. Fisher remain living with her boyfriend, who's going to be the father of her child. And I think that probably makes sense at this point. But it also means if somehow relationships with the boyfriend fall apart, as sometimes they do, then there's a backup for her to go back to Ms. Kulawine and Ms. Rose Hogan-Nickel. So those were my thoughts. I think that's something that you'd probably have to agree to. But Ms. Winkles, in the interim, I guess now I'm wondering if I should extend the emergency guardianship until we get to a hearing. So somebody has authority.
I can so what I can do is I can file the objection this week, set something on the universal trial setting docket, but I think you're right. I think we don't need that. If Ms. Kulawine will, and Ms. Hogan-Nickel, hopefully I pronounced that right, will call my office. Maybe we can come up with some sort of out of the box where Melba has guardianship at this point and they have a supervisory role of that guardianship, and maybe Ms. Fisher returns to their house, or at least has an hour phone call with them, you know, something like every week, so they can check in, they can review what's going on with the child and all of that until my client's 18. The other additional information is obviously my client, the moment she has that child, my client has the authority to then seek emancipation. I don't know if she'll do that. We've spoken briefly about it, but in any event, trials of this sort may not even happen until my client's age. I mean, I don't know. Getting trials been kind of difficult for me lately.
I'm recognizing that, and I think some deference needs to be paid as to where Ms. Fisher wants to stay, but I'm not sure that I want Ms. Kulawine or Ms. Hogan-Nickel to be out of the picture. So I am going to enter an order that extends the current emergency minor guardianship until this goes to trial. I would like the parties to work with Ms. Winkle to try to come up with a solution so you don't have to go to trial. Okay. When I looked at this, the text convinced me that the relationship between Ms. Fisher and Ms. Kulawine and Ms. Hogan-Nickel goes back a ways. It's strong, and so I hope everybody recognizes that going forward. Okay.
And just on my client's behalf, my client is pregnant. So obviously emotions are going to be heightened anyway, and my client's age, obviously. So hopefully we can repair all of these, but I hope some consideration can be given to the fact that my client is pregnant. I was not a happy pregnant person, but we can come to an arrangement and give her a little bit of the benefit of that.
And again, I'm not making an order that she has to move or change her living circumstances at all. I would just like everybody to cooperate to have the kind of authority that's necessary. Okay. All right. maybe I should
Okay.
set a review just to check in on where we're at. Why don't we go a month out and see if we can come up with a solution by then? So that would be June 20th.
And do you need me to draft an order for today, Your Honor?
I've got, let me look at the last extension I did. That may be on my computer. So on number 10, there's one that says letters of guardianship will be issued until hearing, and says the scheduled hearing date is, and I think we just put to be determined in there. And under the statute, there can be an extension of the emergency order until the hearing on the final petition. So that's under that authority. I think I can extend this. All right. Let me go around. Ms. Hogan-Nickel, any questions? Okay.
No, I just wanted Angel to know that we love her and we're for her. I think there's just been some people going around saying that we are trying to do all this stuff against her, and that's not true at all. Like, we've always just loved her and wanted good for her. So,
Ms. Kulawan?
No, I don't have any further questions, Your Honor.
All right. Ms. Langford, any questions?
No, I'm hopeful that this is a solution that will help everyone kind of get everything wrapped up. So I really appreciate the solution a lot. So.
Okay. Ms.
And
Winkles?
if everybody wants to contact my office, maybe we can find a time where we can all meet in the office. And while I represent Ms. Fisher, I can also draft things as we're there. You can take them away and speak to whoever you need, but maybe we can come up with a solution in the office. Ms. Langford, I'd request that you could be there by Zoom. You can set up a computer if you can. I know you've been ill, if that will work for everybody. And we can do it on Zoom too. It doesn't matter, but maybe we all can.
Okay. All right. Thank you, everyone. Then we'll see everybody back here on June 20th. And thank you. Casey Mansker, Ms. Height. Is Casey Mansker here?
It might be under Casey Bowen.
Is Casey Bowen here?
And I've received no response.
Nobody is speaking up. This is a motion to compel.
And this is our second motion, or the review of the first, the motion to compel. This is a review on that. We still have had no compliance. So I'd ask that the second order compelling be signed by the court.
Let me see if I have one to that effect. I don't see that order in the orders that I was given. Would you mind sending one over?
I will have one sent over today.
I'll be happy to sign it.
Thank you, Your Honor.
And it looks like Brian Hunter is on that.
Good afternoon, Your Honor. Brian Hunter for respondent Bailey Koski.
Is Marshall Brock here? I see Marshall Brock. Good. My notes, I guess we're here for a presentation of order, which I'm not sure I can do, if that was what I saw. Well, okay. Oh, there it is. Okay.
Yes.
And then there was a note about visitation resuming. So, Mr. Hunter, why don't you bring me up to speed on this case?
Yes, Your Honor. So we had a contempt hearing was held on May 9th. We had the contempt hearing order was sent to your desk yesterday. It's been agreed. Mr. Brock has signed off on it. The review was to make sure the visitation had went through. There was also an order that the parties contact the child's counselor, Ms. Malloy, and I've confirmed with my client she has been in contact with Ms. Malloy. And I think the next step after she contacted was Mr. Brock would contact Ms. Malloy. So that is where we're at the moment, Your Honor.
All right. I have a proposed contempt hearing order. Let me look at the signatures on it. And it looks like, Mr. Brock, you did sign off on this order.
I did. Yes, sir. Yes, Your Honor.
Okay. So you have no objection to me entering it at this time?
Not that I could think of, Your Honor.
Okay. I'm going to just cross out proposed, and I'll sign what was provided to me.
Understood. Thank you, Your Honor.
And we'll take care of that. Thank you. Anything else in that case then?
No, Your Honor. I believe that was the last remaining business.
Do we need to set a review hearing?
As far as I know, there shouldn't be any need for a review hearing. The parties have completed everything they're supposed to at this point, and the order being entered should be the end of it.
Okay.
Yeah.
All right. Thank you both. Is Mr. Kreiderman here? Are you representing Ms. Kreiderman, Mr. Reed?
I am. I'm representing Mr. Kreiderman, Scott Kreiderman, to draft the quadro that's at issue in this case.
All right. I think there was a plan that was filed, and I think Ms. Gilmore is moving for contempt because it wasn't done or wasn't done timely. So I'll let Ms. Gilmore lead us off, and then we'll go from there.
Thank you. Director Megan Gilmore on behalf of the respondent and moving party, namely Tanya Kreiderman. This is before the court on my client's motion for contempt. As explained within that motion, a final divorce order was entered in February of 2022. Within that order, husband was to timely pay for all quadro costs so that those quadros could be entered in good faith. As we've set forth within our motion, after numerous contacts with his previous attorney over the last 13 to 14 months, orders had still not been entered at the time the motion had been filed. By way of update, the quadro for the pension has since been entered. However, there has been no quadro entered for the 401k for the, I believe, $26,000 or $24,000 that's supposed to be awarded to my client. So now we're sitting a year and a half after the final entry of orders. My client, frankly, is on disability and has a net income that's lower than $1,000. This is our third motion for contempt to simply just get this case closed. I did receive communication and email from Mr. Reed about 18 minutes before the docket started with a draft of the quadro 401k. I will review that. I do agree that it needs to be pre-approved by the plan prior to entry. But at this point, we're simply looking for fees. We had to bring this motion for him to retain counsel to bring this matter before the court after years. Frankly, my client has been charged over $2,000 simply just to get an order entered. So we do ask the court find contempt for the willful intentional violation of the court's order and award my client fees for having to bring this action. It's my hope. Let's set this on. I would ask that regardless of the court's ruling that we set this matter on for a review to just keep for tracking purposes to ensure that quadro has been entered. But I would ask the court, again, award fees, find contempt, and set a review. Thank you.
And how much are your fees? 2,000? Is that what you're asking for?
Yes.
All right. Mr. Reed?
Your Honor, I was hired just a few weeks ago to draft the order in this case. I spoke with Ms. Gilmore at the beginning of the month. I actually was under the impression that this hearing was going to be set over, so it wasn't even on my calendar for today. It's been 3 weeks since I've been on this case. I drafted an order and sent it over to Ms. Gilmore. Like I said, I just wasn't expecting that we would have a contempt hearing, at least not this quickly. Having only been on the case for a short time, I can't speak as to my client's ongoing issues, but we have done what we need to do to draft an order, and we're ready to forward it pending Ms. Gilmore's comments.
Mr. Reed, this is no reflection on you at all. But Mr. Kreiderman has had, as Ms. Gilmore indicated, a year and a half to put this together. And one of the things that I look for is, did it take the motion to get somebody motivated to do something? And it seems clearly that's the case here, that the pending contempt motion is what caused him to hire you to get involved. So I think Ms. Gilmore is entitled to fees for having to take that step, and it's not the first time. So I'm going to award. I'm going to find contempt for not doing the quadros timely. I'm going to award fees of $1,500. And Ms. Gilmore, if you could put that order together, then I'll sign it. And we'll set a review for June 6th. Will that work?
Give us some more time just to be sure. Let's do 4 weeks, or at least 4 to 5 weeks.
Okay.
Mr. Reed, what do you think?
I would even recommend more than that, because it could take significantly longer to hear back from the plan. The review that we can have at that point would be whether we have an order, whether we've come to terms on what it is and submitted it for pre-approval. But I think it's unlikely that we'll get a response back that quickly.
Let's set it just on for, I think, June 27th. If we need to set it over and at least we have communication, I'm fine doing that, but at least for tracking purposes. Does that work for you?
It does. Thanks.
All right. We'll put it over to June 27th, and I'll look for the order. All right. So I want to clarify what we're doing today. On May 30th, I think you've got a motion for adequate cause temporary orders, and it also says restraining order, but it looks like we're here for a restraining order today. Is that right?
Well, it's what we wanted to do, and I don't know how far you delved into the file, but this is one that's been, very traumatic over the past 7 or 8 months.
I understand the child's it's still in Mexico.
No longer. The FBI was able to remove the child from Mexico, and child is here and safe and doing well with dad and back into the routine. And frankly, I look at that now as a complete different set of eyes, knowing the difficulties that is once a child is taken and absconded with across borders. And that has been, frankly, the vein of, I think, everybody's existence over the past 7 or 8 months. He's here. It's a happy ending to that. Now we just need orders in place and insurance to make sure that that never happens again. And the first step in that was the restraining order. I think Judge Bassett's intent on noting that for the 23rd was just to give us time to extend the existing order. So we are asking today that be extended somewhat, again, just to give us a buffer. We don't anticipate that mom is going to come back to the United States. She obviously is now facing some pretty significant criminal charges on various levels. She does not have the right to be in America at this point. So we don't anticipate she's going to come back. But again, after all that this young boy has been through at the hands of his mom over the past several months, we just want as many protections in place as we can possibly get. We have attempted service. Of course, that again was extremely problematic given the circumstances. Judge Hahn did sign an order to have service by mail permitted. We've done that, and as the court can see from the information that was returned on that proof of return service, we got information from her last apartment complex that indicated she was deceased. We don't believe she's deceased. We think she's alive and well down in Mexico. Well, alive, probably not well, but alive down in Mexico. And for whatever reason, getting service to her is going to be extremely problematic. But nonetheless, I think everybody certainly understands and appreciates the very unique circumstances of this case. So today I'm just asking you to renew the restraining order. If you're more comfortable doing that next week in front of Judge Fassett, I'm certainly agreeable to that. I don't want to leave any kind of a period of time for mom to come back and basically affect chaos on my client, or most importantly, this child.
All right. I need to call, is Griselda Pera here or anybody representing her? All right. I have no problem signing an extension of the restraining order. If you want to put that together and provide it to the clerk for me to sign, I'll do that.
My plan is to probably give a 30-day window on that. And then at the hearing next week for adequate cause, we could probably, I believe the time for her to respond is over. Theoretically, then we'll probably ask for the extended final restraining order that goes until this child's 18th birthday, pursuant to what I believe we can do under the statutes.
Okay. All right. So
on an ex parte basis,
that'll be fine if you want to provide it to me. And then next week, if you need any subsequent hearings, you can set those next week. Ms. Day, I think we're here for an interim GAL review. And so, and the state might be involved in this also. Go ahead, Ms. McLean.
Thank you. I spoke with Ms. Day yesterday, and then I emailed Ms. Dow just shortly about the fact that apparently, well, first off, my client hasn't been able to provide any input to the counselor for Mr. Gilman's mental health evaluation. I think that I know who's doing that now, and I forwarded contact information to my client, so I've instructed her to reach out. But based on my discussion with Ms. Day yesterday, she's not received a report and was requesting to set it over a month. I have no objection to setting it over to June 27. I'm hopeful that we can get his evaluation. I'm not sure if Ms. Dow or Ms. Day are available that day.
Your Honor, so far, it looks like I am available for that afternoon calendar. My client has contacted Ms. Day and Ms. Gilman directly with information for the evaluation at Core Health. So it sounds like there was a little bit of a misunderstanding about who is going to reach out to whom, but it sounds like everybody's in contact now, and we should be able to get the information together for that hearing.
All right. Do you have any objection to putting this over that to
No, Your Honor.
27?
No.
Okay. Ms. Day, does that work for you?
That does work for me, Your Honor, as long as we could be first on the docket. I have a settlement conference that I have to appear in Lewis County at 2:30. So that would be my only request if possible.
I can't really grant that now. I think you'll have to send an email to
That's fine.
Judge Fassett's judicial assistant prior to that hearing.
No problem. Thank you.
Okay.
And Christine,
All right.
would you mind forwarding me that contact information?
Yes, actually, somebody should be delivering a big envelope to you this afternoon.
Okay.
It's
you.
in there. Thank you.
All right. So Gilman and Gilman over to final amount. Oh, Mr. Rapp is here. Let's go to Mr. Zandy first. Was the remaining amount paid, Mr. Zandy?
well, here's the information, Judge. You heard this a couple of months ago. This has passed hands quite a bit from Judge Scudder to Commissioner Baldwin to Commissioner Nelson to Judge Fassett on these various review cases. Existing orders that Mr. Rapp pays $1,250 per month. Over the last couple of months since we were last in court, my client did receive the tax return on the 26th of April, I believe, in the amount of $2,000 or thereabouts. We received a couple of cash payments that have kind of flowed in various amounts. The end of March, there was one for $300. There's one for $500, another for $750, for a total of about $3,550. If you extrapolate what's to have been paid since the order was entered in October, that'd be about $10,000. And he's paid about 30% of that. Now, currently he's $6,450 in arrears. So we're getting small amounts of money at very unpredictable time. I would certainly argue that he hasn't complied with the prior orders. We're still here again. My client, unfortunately, again, continues to go backwards on this with reviews and contempts and enforcement motions. I'm not sure at this point really what we do. Again, I know that jail time is the last resort, and I'm not suggesting we do that at this point. But again, we've tried everything else. So here we are. We do have a settlement conference at the end of June. I'm hopeful that we can sit down and piece this together and figure out some kind of a resolution that's going to make sense for everybody. But at this point, it's frustrating to my client to continue to go month after month without the court awarded maintenance that she frankly desperately needs to make ends meet.
All right, thank you. Mr. Rapp, any response?
Yep.
Go ahead, please.
Yeah, I'm doing the best I can with what the money I have. Like right now, I called in late. I'm working today to make some money. I only get so much a month. And I got a lot of bills. I'm doing the best I can. I'm trying to get reverse mortgage, but there's a few things I have to do to the house before I can do that. I was going to put new carpet in like I was supposed to for refinancing, but I ended up giving her all the income tax. So I'm waiting to make some money so I can put the carpet in there, get my reverse mortgage going.
Mr. Zandy, have you seen recent pay stubs from Mr. Rapp?
I have not. If we did receive those, it might have been while I was out. Today's my first day back from vacation. I have not seen pay stubs. I don't believe, again, Mr. Rapp's on Social Security and receives a retirement. I don't think that has changed or changed drastically. It was presented at the last couple of hearings that he's at an age now where he doesn't want to work anymore, that he's effectively retired. So this is the first I'm hearing that he's actually pursuing work and doing anything.
All right.
No.
Well,
Your Honor?
Yes, sir.
I've worked a couple days for J.H. Kelly already this year and given it to Cheryl, whatever I made.
Okay.
I'm supposed to be going to work for him here, but I'm a cement finisher and I have to wait for them to get it ready to pour. Today I'm doing a little side job.
All right, sir. What we have is a court order that requires that you pay $1,250 a month. You've indicated that you're doing the best you can. And I think Mr. Zandy has the right to verify whether that's true. So between now and June 13th, I want you to provide evidence of all of your income. So if you have direct deposit of Social Security and a pension, you need to provide him the last 3 months of your checking account statements. Just a minute, let me finish.
It's all been the same, Your Honor. He has all that. It's all been the same.
Well, I want it updated. Okay.
All right.
And then second, you've indicated that you're working. And so whatever you're earning working in the last 3 months, I want you to provide that to Mr. Zandy. And then I'm going to continue this hearing. I think it's a contempt hearing. Well, it's a review. I'm going to continue this hearing to June 13th. And at that time, Judge Fassett can determine whether or not you're able to make the $1,250 a month payment. Okay.
Well, I can't, but I'm doing everything I make goes to her.
Okay.
I'm behind on my bill.
All right. Then we need to be back here on June 13th. All right. We'll see you then. Thank you.
What time?
1 o'clock.
All right. Thank you.
And on Zoom, just like today. All right. And
all right, thank you.
Is Brittany Erickson here? Nobody is responding. So I've got a presentation of order, which I may not be able to do unless it's agreed to, but also a review hearing. So Ms. Winkles, why don't you bring me up to date?
Yeah, so I doubt you'll be able to do the presentation of the order. It would be a temporary order with a parenting plan and also a compel hearing. This is the review for the compel.
Okay.
And a review of the hair follicle. The hair follicle was done by both parties. We can set that for when the Judge Bassett gets back. But the compel has still not been handled. And so I would ask for a second order because the original one had, in any event, that's the oral order of the court that today we were supposed to have those documents by today. I've not received them. I suppose if I don't receive them by 5 p.m., I can wait and give you the order tomorrow. But in any event, I've received absolutely nothing. And there is a protective order that we agreed to at the last hearing that's in there, still have not received a single document. So I'd ask that the second compel be signed by Your Honor.
All right. I did see that there was an agreement to a protection order or protective order relating to those documents. All right. Why don't you wait till 5 today? If you don't receive anything, then present an order to me tomorrow and I will take care of it.
Sounds good. Thank you, Your Honor.
All right. Thank you.
So can we set the other hearing over? I'm not sure when Judge Bassett's back.
Next week is closed, so we'll have to go to June 6th.
Fine.
So, Mr. Hamir, I think was going to ask for a set over, and I see Mr. Brown is here, and it looks like Ms. Teeters is here also. All right, Mr. Hamir, why don't you go first, and then we'll go.
We're respectfully moving for a continuance on this matter. It has come to my attention that we had filed a response with respect to this matter timely, and our service provider had indicated that they did not serve it, and not only that, that the service provider was actually terminated at the company. As a result of that, we reached out to Ms. McLean and her team to let her know that this is what has happened. She had stated, "Why don't we send a copy of the pleadings over to the court," which we did yesterday. It is, which is fine, but the concern that I just came to know of this morning, and something that we did initially provide with our initial with our initial filings for our service providers, was the pay stubs. And we don't. It's come to my attention that we, even though we actually had it with the service provider, we did not get it into the court yesterday. As a result of that, we're asking for a very, very short set over so we can address all these issues and handle the matters all together. Although we are prepared to proceed on a couple issues, I think that it would be more fruitful and more beneficial that we can handle this in a holistic approach. Thank you, Your Honor.
Thank you, sir. Ms. McLean?
Well, this is the first time I've heard anything about pay stubs. I haven't received any courtesy copy of pay stubs. They weren't even addressed in Mr. Brown's declaration. And I guess my first question to the court, when I was communicating with Mr. Hamir yesterday, was, have you read Mr. Brown's reply declaration and my client's SIR reply?
I read your SIR reply. Mr. Brown's declaration as of yesterday afternoon was not, had not come through Odyssey. Let me see if it has now.
Your Honor, I emailed it.
Yeah, it was emailed to court administration. I think I was included in that. And we had also provided a courtesy copy to court administration. So what my request would be, just because we are under an a second ex parte order, I think that this needs to be heard today, particularly in regards to the restraining order and the parenting plan issues. Ms. Day is here as well. It's not as if this matter could be set over a week, because next week's docket is full. It's already been closed. So I would ask that you just put this at the end of your docket. We'll take a brief break so that you can review through that and proceed with our hearing.
All right, those documents are now in Odyssey and I can review them. I think that request makes sense. Let's do that, at least initially here.
Okay.
All right, we're almost, actually, I think we are at the end of the docket. So why don't we go off the record? If you just hang on Zoom when I'm through reading these, and we'll go back on record and I'll take the arguments.
We'll tell the court, obviously, Mr. Brown's response clearly is an attempt to collaterally attack Ms. Teeters' character. And despite his claims, my client tells you that this is not about his new girlfriend. It is not about his perception that my client needs to win. It is my client protecting her daughter, who's making disclosures about being inappropriately contacted or touched by her father. And it is about not only that substantive testimony, but about the significant emotional reactions that this child has had that's been observed by other professionals involved with this child. For example, you have Lauren's school teacher who reports about Lauren uncharacteristically engaging in sexually charged play with other peers within the classroom. My client isn't there within the classroom encouraging her daughter to do this. This is learned behavior, and it's behavior we believe that she's learning from Mr. Brown based on the behavior that he's engaging in with his own daughter. So our position is that the court take into consideration all of the evidence that's been submitted. And again, I think it's typical when we've got pending criminal allegations and investigations that we certainly do everything possible to protect a child, to ensure that this child is not going to be further victimized, and to ensure that law enforcement is able to do their investigation. And so we believe it is wholly appropriate to maintain the no contact between Lauren and her father. To that end, because we want to protect her from any further victimization, I have provided proposed orders to the court. Within the parenting plan, if you take a look at page 2, paragraph 4, I've given you 2 different options. One was for no contact, one was for supervised contact. At this juncture, law enforcement has not concluded or closed their investigation. It remains ongoing. Therefore, we're asking that the court mark the first box under 4A that provides for no contact with the child. We're also asking then on page 4 at the bottom that for paragraph 12 that you mark does not apply, because there wouldn't be any transportation necessary if there's no contact. We are also asking the court to enter a restraining order after today's hearing. If we do not have a restraining order in place, then there is no order, there's no current active order in the sexual assault protection case. And so we're asking the court to enter an affirmative restraining order here. We are asking that the court at page 2 under paragraph 4 mark the first box that identifies that Mr. Brown is present for this hearing and that he received actual notice of this hearing. And then on page 3, we're asking that you mark the second box at the bottom of paragraph 7 that indicates that service is not required because he was present or his lawyer, either he or his lawyer signed or was at the hearing when the order was made. And since, again, Mr. Brown is present, we think that that's appropriate. In regards to financials, it is accurate that Mr. Brown has not provided financial documentation. I assume at this juncture that our numbers are correct. We did provide, as part of our financial documentation, the actual schedule of earnings for an individual through the Kelso School District where he's employed. I believe based on those figures, his number of years as a teacher and his years of education, that his net would be approximately $4,670.06 per month. My client's current net income is $3,463.14 per month. And we've also provided under sealed financial source documentation, the verification that my client pays $43 per month to cover Lauren on her health insurance. Now, originally in the 2020 case, there was a temporary child support order. That temporary child support order provided a temporary child support amount of $472.19 per month. And that was paid, I believe, through the registry. Since that case was dismissed for want of prosecution, Mr. Brown continued to voluntarily provide those payments or to make those payments up until this month. My client has received no child support for the month of May. Based upon the child support calculations and the child support order that I've provided to the court, we are asking the court to set current child support at $759.40 per month, commencing April 1 of 2023. As this matter was filed back on April 3 of 2023. So we believe that that's appropriate. In addition, given the basis for having to come into court, the underlying concerns in order to protect Lauren, we are asking that the court consider the financial differences between the parties, the fact that my client wouldn't be here but for the concerns and allegations, and we're asking that the court award my client $2,500 in fees. As you can see from the court record, originally we were requesting the appointment of Ms. Day as a guardian ad litem in this case. That order has already been entered, and we've already scheduled review hearings and the like in regards to her report. The guardian ad litem order was actually entered back on May 8th with a final review November 14 at 1 p.m.
All right, thank you.
You're welcome.
Mr. Amir?
I'd like to start first with the sexual assault allegations and the protection order and the restraining order. I'd like to first start off that the guardian ad litem and the child protective investigations have not validated any of these accusations. The court can only issue a protection order if there's clear preponderance of the evidence demonstrating an assault. When we look at the petitioner's motion, it's primarily based on hearsay, and it's primarily based on allegations that cannot be concretely verified. It's also important to note that law enforcement has been contacted. However, my client has not been. There has been no interview by the police. There's been no charges. My client has not heard from any type of law enforcement whatsoever. My client also indicates that these allegations should not infringe upon my client's rights, parental rights. He firmly denies these claims, and he wants a fair resolution to these matters without causing further distress to his reputation or his daughter's emotional well-being. My client also indicates that all these allegations have started when his current girlfriend, Kirsten, started to move in with him. And when this happened, the allegations of sexual assault and so on and so forth, all of a sudden just have come up. And he's concerned that the allegations are more out of spite than it is with respect to the hard facts. With regard to the allegations of costs and fees related to these proceedings, detailed in Section 15, my client is also stating that these allegations are also unsupported and they're levied against my client, and he should not be burdened with these financial obligations. Lastly, with respect to the issue of child support, my client is committed to his fatherly responsibilities, and he is seeking an equal shared custody arrangement for his daughter, Lauren. He's not intending to evade his financial responsibilities, and he's seeking an adjustment of the child supports to reflect the time that he shares with his daughter. DCH also has recognized an overpayment of $5,300, which should be considered in future payment calculations in accordance with the statute. I should also state that my client, his girlfriend started moving in November, and that's when all of a sudden these statements have come up. He is not, CPS has also indicated to my client, that it's unfounded, again, on the second note. And also, he lastly contends that these allegations are false, and he's upset that he's being accused of these, and he finds that it's very spiteful. Lastly, and most importantly, my client is paying the $472 in fees. In child support. He makes $3,100 a month. Those payment stubs were provided to the court initially, but apparently it didn't get to the court at this time. So those are the concerns that my client has. Thank you, Your Honor.
All right, thank you, Mr. Hamir. Ms. Day, I don't know how far you're into this case, but I'd like to hear from you.
So I have not begun the new investigation. My information kind of concluded at the end of the sexual assault investigation. I am aware of the new information provided by Ms. McLean. My recommendation at that time that I wrote my report was that there be supervised contact between father and Lauren, believing that that is the least restrictive and still protective of Lauren. But based on the information that there may be a new allegations and new investigation going on, I think that's maybe not a wise decision at this point. I've not been able to follow up on that. That information is new to me, but I do plan to do that and meet with both the parents and move forward with this investigation as soon as I'm able to. It was understood when I accepted this appointment that I am not able to be actively involved at this moment, just based on my current caseload. I'm trying to get through some of the cases that I have first before I start with this one, but I will be following up with law enforcement to find out the status of their investigation and also to see if another CJAC interview has been scheduled.
All right, thank you. Ms. McLean, any response to any of that?
I just want to make sure I understood Ms. Day's recommendation. So based on the representation that there is now another active law enforcement case, your recommendation is no contact?
Yes, that's generally appropriate when there's a case like this that protects both the child and, in this case, the other parent who might be being accused of something. When you have a young child like this that these kind of allegations are being involved in, the concern is always to not have the witness tampered with. So contact could be contrary to that investigation, and that's not my intent. But I would need to confirm that with law enforcement. But that's my understanding, is generally when there's allegations like this, there's no contact between the victim and the alleged individual who may have committed the act.
Okay, thank you for that clarification. So just briefly in response, my client tells you that there is this active case with Kelso Police It is case number 235287. I did also speak with Detective Eric Swenenson to confirm that they did have a new opened and active case, which he confirmed. My client had also provided the documentation that indicated that CPS also has an active and open case. So we would agree with Ms. Day's recommendation for the continuation of no contact pending the outcome of those investigations. In regards to the child support issue, I have not seen anything, or my client hasn't received anything from DCS that suggests that there's been an overpayment. However, the statute of limitations is clear under RCW 26.26B.040 that there's a 5-year statute of limitations. We also have best evidence of the prior child support order that would provide the $472 and some odd cents per month in child support. And again, we have my current calculations for child support moving forward. So if anything, in light of the representation or argument by counsel that there is an overage, I would simply ask that the court interlineate language in the child support order that I've provided to the court. And I think that it would be appropriate at paragraph 1 of 2023, then we'd have from May of 2022 through March of 2023, that ultimately the court can make a determination of what the appropriate amount of child support is compared to what my client received. The only other thing that I would point out is that, as counsel indicated, Mr. Brown's girlfriend moved in with him in November of 2022. The behavior by Lauren actually predates even the July 2022 allegation of Mr. Brown urinating in a bottle in front of his daughter. There were incidents during the 2020 case that my client had also made notes of, and all of that can be reviewed by Ms. Day during her investigation.
All right, thank you, everyone. These are difficult cases, particularly where there's statements that oppose each other on each side. And the court is in a position, as I think anybody can determine, if I make one decision, I may put the child at risk of further harm. And if I make another decision, I've denied a father his time with his daughter. And those are difficult decisions to make. My overriding concern when I'm faced with these decisions is what is going to protect the child. And so right now, whether it's warranted or not, what we know is there's a open Kelso Police Department investigation and an open CPS investigation. I don't know what the results of those are going to be. We know the prior ones were either dismissed or came back unfounded. If these came back with the same result, I think that certainly would be strong evidence that Mr. Brown should have contact with his daughter. But I don't know what they're going to come back with in terms of a conclusion. And right now, I think there's also a concern that until those investigations are complete, if Mr. Brown has contact with his daughter, there could be, right or wrong, an argument that he tried to influence her testimony or her attitude about it. And then I don't think Mr. Brown should be put in that position. So consequently, I'm going to have to accept what Ms. Day said, and really it's what Commissioner Carmi had ordered, which was until the end of the investigations, there will be no contact between the daughter and Mr. Brown. I'm sure Mr. Hamir will follow those investigations, and once there's a result, particularly if they're dismissed and unfounded, you should immediately put this back on the court docket, because there should be supervised or some other type of visitation that occurs at that time. But for now, I'm going to order no contact, and I will sign the restraining order. Mr. Hamir, I think, indicated that there were some additional financial documents he wanted to present relating to the child support. So I'm going to defer on that and put that over to June 6th and allow Mr. Brown to submit additional documents on that issue.
Got a deadline date for those to be received? Because I'd like to have an opportunity to at least respond.
Sure, that's appropriate. So today's the 23rd. How soon do you think you can get those documents into the court and to Ms. McLean?
I should have it. I'd like to say by the end of the week, but I know for sure by Tuesday I can get it in. I'm in Europe right now, so I'm actually flying out tomorrow to deal with
Let's say they have to be received by Ms. McLean, and that can be through email on May 30th.
That'll work.
And then the hearing will be on June 6th.
All right.
And then Ms. McLean has asked for attorney fees. I'm going to defer that. I think, well, I'm probably not going to hear this docket. If I was, I'd want to see the result of the investigations before I made a decision on the attorney fees. Okay. So I'm going to defer that. You can raise that in the future, depending, you can raise it in the future no matter what.
So if you would, on the temporary order that I provided to you, if you would just strike the judgment summary in paragraph 1.
Okay.
And then at paragraph 6, again, if you would just strike that language and just say deferred for further determination, or however you want to.
I'm not denying it, but
all right.
It's deferred.
The other issue was, and I'm sorry I didn't bring this up in my argument, was whether or not the court was going to require Mr. Brown to undergo a hair follicle test. That is language that's in paragraph 8 of the temporary order.
We haven't addressed that. Mr. Amir, do you want to address that issue?
Yes, Your Honor, I'm going to object to this. There is absolutely nothing that supports, except for an unfounded allegation of marijuana and a porn addiction, that there's nothing that alleges that my client has any substance abuse problem. Moreover, and more importantly, has anything to do with his fitness as being a father. So we're strongly objecting to that request. Thank you, Your Honor.
What's the evidence of any kind of illegal substance abuse?
Well, previously in the original 2020 action, there were allegations and information about that included Mr. Brown acknowledging that he was using marijuana. There was a limited parenting plan originally at 3 hours, 3 times a week. I believe that was supervised initially. And he was ordered to undergo a hair follicle test before visitation was allowed to expand. Obviously, visitation did expand. I can tell the court that when I went back and looked at that 2020 case, I couldn't see where there had been a sealed health record filed, but I wouldn't have been able to access whatever the results were had there been, because I'm not a party to that, or I wasn't the attorney in that action. So those were simply concerns that were raised by my client based upon his history.
Well, after that, they voluntarily engaged in a weekend on, weekend off visitation plan with some midweek visitation, it sounds like. That went on for quite a while until the recent allegations. The recent allegations don't have anything to do with drug use. It has to do with other issues. So based on that, I don't find that there's the underlying evidence that would support a hair follicle test. I'm going to delete it from the temporary order. Obviously, if there is some basis for it in the future other than what occurred back in 2020, because the parties, as I said, acted in a way where Mr. Brown had no issues. But if something comes up, obviously you can ask for it in the future.
Okay.
Your Honor, did I hear correctly that the remaining issue with the finances is June 5th? I would ask to be excused from that hearing.
June 6th.
Oh, 6th.
Tuesday the 6th, and I think you can be excused from that hearing. All right, I'm marking the first box on 4A in the parenting plan. No contact with the child. And I'm going to write to be reviewed after conclusion of investigations.
So then the question is I did provide for Mr. Brown engaging in a psychosexual evaluation at paragraph 4B. Is the court going to order that at this juncture, or are you reserving that as well?
I think I'll reserve that.
Thank you.
All right. Also, number 3, as I said, A1A says Alan Brown has assaulted or sexually assaulted someone causing grievous physical harm. I don't think that's been determined yet, so I'm going to reserve that also.
Okay.
Yeah.
E1A, I haven't heard any evidence of abusive conflict. And honestly, looking at the text messages that were provided, I would say that as Ms. Teeters that uses language that is more insightful and more concerning. Mr. Teeters seemed very, his text messages did not seem as sharp. And anyway, I'm going to reserve on the abusive conflict.
Okay.
I am going to leave B, however, because that's just a statement of fact. The minor child has made disclosures of sexual assault to at least 2 separate counselors. Thank you all.
All right.
Thank you, Honor. Thank you, Counsel. Thank you, Ms. Day.
Thank you.